My Lord, I would to take you now to the second reference in FII, which is in volume 8 of the authorities behind tab 73. I'm not going to take you to the Advocate General's opinion, but on this issue as a summary, it's quite amusing to read in the light of what the court decided. His conclusion was that he didn't think much of the court's reasoning in the first reference, but he thought, as a matter of construction of the judgment, then that what the revenue said must be right. But he then went on to consider, in passing, the kind of argument that the court accepted, and described it as intellectually incoherent, I think, something like that. So,
well, you can't please the juge rapporteur by saying he didn't think much of the reasoning in the first case. But
yeah.
Anyway.
Wouldn't have thought so. But anyway, the Advocate General obviously was playing his own furrow in this. But what the court said, you can find, the court had to consider what was the question that had been referred. The issue was whether rates of tax meant nominal rates or effective rates or both. And the conclusion that they came to, you can find on page 2808, paragraph 49 of the judgment. After dealing with the various arguments, they concluded that the determination which the referring court was called upon to make by the court in paragraph 56 of its judgment in the first reference relates both to the applicable nominal rates of tax and to the effective levels of taxation. The tax rates to which paragraph 56 refers relates to the nominal rate of tax, and the different levels of taxation relates to the effective levels of taxation. The effective level of taxation may be lower than the nominal rate of tax by reason in particular of reliefs reducing the tax base. And then they continue, as regards any difference between the nominal rate of tax and the effective level of taxation to which the resident company paying dividends is subject, it is admittedly apparent from paragraph 56 of the judgment in the first reference that the exemption and imputation methods do not immediately cease to be equivalent as soon as exceptional cases exist, in which nationally sourced dividends are exempt, although the profits out of which those dividends have been paid have not been subject to, in their entirety, to an effective level of taxation corresponding to the nominal rate of tax. The court made it clear, however, that it was the referring court to determine whether or not the difference between those rates was exceptional in nature. And then they conclude at paragraph 51 that the national court had determined that it wasn't exceptional. There are obviously quite a number of cases in which a UK company pays tax at a lower effective rate than the nominal rate. And then they continued, paragraph 52, it follows that application of the imputation method to foreign source dividends as prescribed by the legislation at issue in the main proceedings does not ensure a tax treatment equivalent to that resulting from application of the exemption method to nationally sourced dividends. And then paragraph 53, they conclude that the positions are not comparable, so that the difference in the tax treatment is not justified by the relevant difference in situation. Therefore, the legislation constitutes a restriction on freedom of establishment. Now, that's where the matter stopped in the first reference, but in this reference they go on to ask whether it was justified by an overriding reason in the public interest. And they record in paragraph 56 that the UK government had contended in the original reference that the rules were objectively justified by the need to ensure the cohesion of the tax system. And then they set out in paragraphs 57 and 58 the case law on the cohesion of the tax system justification. And they say at paragraph 59, having regard to the objective pursued by the rules at issue in the main proceedings, a direct link exists between, on the one hand, the tax advantage granted, namely the tax credit in the case of foreign sourced dividends and the tax exemption for nationally sourced dividends, and on the other, the tax to which the distributed profits have already been subject. So They say there is a direct link, which is what is required for cohesion. However, they then turn to proportionality. As to the proportionality of the restriction, whilst application of the imputation method to foreign source dividends or the exemption method to nationally sourced dividends may be justified in order to avoid economic double taxation of distributed profits, it is not, however, necessary in order to maintain the cohesion of the tax system in question that account be taken on the one hand of the effective level of taxation to which the distributed profits have been subject to calculate the tax advantage when applying the imputation method. That's the foreign profits they're talking about. And on the other, of only the nominal rate of tax charged on the distributed profits when applying the exemption method. So the court is, as I think your Lordship said this morning, treating an exemption as a credit at the nominal rate. That's the line of reasoning. So they assimilate an exemption system with that.
An exemption means that the person receiving the dividend domestically doesn't have to pay any tax on it, and he therefore gets a credit at the nominal rate, does he? Or whatever.
Well, you might say he gets a credit at the effective rate, because that's the only rate his effective rate. That's the rate he pays. But anyway, that's not the way the court looked at it. Yes. It's slightly strange reasoning, because the credit is never going to be the nominal rate on an exemption. It will always be something different, because
he's just exempt from paying whatever tax he would have paid.
Yes, but he wouldn't have paid tax at the nominal rate, is the point, obviously, except in exceptional circumstances. Well, but anyway,
yes, at the marginal level, he might have done.
There might be companies who, by coincidence, paid at the.
Yes, I see.
There might be.
Yes.
Of course, companies can pay it higher than the nominal rate. That's another point. You can have an effective rate that's actually greater than the nominal rate. The exemption would also cover that, presumably. But anyway, that's the reasoning of the court.
Yes, and this is all in the context of the question which they formulated in paragraph 36.
Yes. Yes, that's right. Yes. They then say in 61, the tax exemption to which a resident company receiving nationally sourced dividends is entitled is granted irrespective of the effective level of taxation to which the profits out of which the dividends are paid were subject. So that's the point I was just making, that it applies whatever the effective rate is. That exemption, insofar as it's intended to avoid economic double taxation of distributed profits, is thus based on the assumption that those profits were taxed at the nominal rate of tax. See, I'm not sure that's actually quite right, but anyway, that's where they look.
Sorry, where are you reading?
In the hands. So it's paragraph 61. Yeah. The exemption is based on the assumption that the profits were taxed at the nominal rate of tax in the hands of the company paying the dividends. It thus resembles grant of a tax credit calculated by reference to that nominal rate of tax. For the purpose of ensuring the cohesion of the tax system in question, national rules which took account in particular also under the imputation method of the nominal rate of tax to which the profits underlying the dividend paid have been subject would be appropriate for preventing the economic double taxation of the distributed profits and for ensuring the internal cohesion of the tax system, while being less prejudicial to freedom of establishment and the free movement of capital. And then they deal to some extent with Haribo in the next paragraph. It's to be observed in this connection that in Haribo, paragraph 99, the court, after pointing out that the member states are in principle allowed to prevent the imposition of a series of charges to tax on dividends received by a resident company by applying the exemption method to nationally sourced dividends and the imputation method to foreign sourced dividends, noted that the national rules in question took account for the purpose of calculating the amount of tax credit under the imputation method of the nominal rate of tax applicable in the state where the company paying dividends was established. And that's recording, I think, what we've seen in a very short form, what the system, the administrative simplification in Austria. But it's important to note, I think, in this respect, the difference between paragraph 62 and 63. 62 is where the court is making its decision, if you like, in this case or in general. It says that national rules which took account in particular also under the imputation method of the nominal rate of tax to which the profits underlying the dividends paid have been subject. So, and we'll come on to that very soon. This difference between the nominal rate of the company, the foreign company paying the dividend across the water, and the nominal rate applied to the profits, to which the profits have been subject. Whereas in paragraph 63, they record that the Austrian system was to allow them to take account of the nominal rate of the state in which the company paying the dividends was established. But of course, you'll remember that in the Austrian system, you still also had to show that that rate that was actually applied to profits. In other words, it wasn't good enough that the company was exempt, for instance, who paid the dividend. So in fact, the two things really come to the same thing. And then they conclude this by saying it's true that calculation, when applying the imputation method of a tax credit on the basis of the nominal rate of tax, which the profits underlying the dividend paid have been subject. This is again emphasising it's on the profits underlying the dividends, may still to a less favourable tax lead to less favourable tax treatment of foreign source dividends as a result in particular of the existence of the member state of different rules relating to the determination of the basis of assessment for corporation tax. However, it must be held that when unfavourable treatment of that kind arises, it results from the exercise in parallel by different member states of their fiscal sovereignty, which is compatible with the treaty. And then they give the answer in paragraph 65. And while you were here, I just show you briefly what they say about ACT. If you recall, there was a question about corporate roots as to whether you took account of the tax paid further down. And they answered that question beginning at paragraph 66. And in particular, if you look after paragraph 70 on page 2811, they're rejecting the argument of the UK government.
But what? What is the argument?
The argument was that what it said in the first reference was that you took account of the tax paid by the company paying the dividend only in determining what ACT credits should be granted. And what the court was making clear is that you take account of all the tax paid all the way down the chain. So paragraph 72 in particular, as is clear from paragraph 62 of the present judgment, the obligation imposed on a resident company by national rules, such as those that issue in the main proceedings to pay ACT, when profits from foreign source dividends are distributed, is in fact justified only insofar as that advance tax corresponds to the amount designed to make up for the lower nominal rate of tax to which the profits underlying the foreign source dividend have been subject, compared with the nominal rate of tax applicable to the profits of the resident company. And then in this connection is little account whether the non-resident company which pays dividends to its resident parent company is itself liable for corporation tax, provided, however, that the distributed profits have been subject to corporation tax. What they're saying in paragraph 72 in shorthand is, as regards corporation tax, you compare the foreign nominal rate, whichever relevant one it is, with the UK rate. So if the foreign nominal rate is lower than the UK nominal rate, the UK is entitled to charge corporation tax up to that amount. So if there was a 10% difference, let's say, you could charge 10% corporation tax. And equally, if you can charge that corporation tax, you can equally charge ACT, which is an advance payment of the corporation tax. So they're assimilating the two things, saying that the amount of ACT you can charge is linked directly to the amount of corporation tax you can charge.
Ensure equality, yes.
Yeah. Well, this is based on the conceptualisation by the European Court that ACT is an advance payment of corporation tax.
Yes.
in respect of the particular.
Well, is it wrong, that
Dividend.
conceptualisation? I thought that's what it really is. You do quarrel with it?
Well, it's one way of looking at it. I think there are a number of ways of looking at ACT. I don't quarrel with the fact that ACT is set off against corporation tax, so it can be regarded as an advance payment in that sense. It's obviously called advance corporation tax.
Right.
But it's not the only role that ACT plays.
Right.
But,
Yeah.
but what they've done is take that and build upon it to decide that the ACT charge is directly linked to the corporation tax charge in relation to those particular dividends.
So 73, it's saying it doesn't matter whether the Water's Edge foreign company actually pays the tax. What matters is that somebody's paid it up that side of the water.
Yes, that's right. In relation to those profits. So the profits are distributed up through the chain. Corporation tax is paid somewhere.
And your submission ultimately is that this is all as unclear as you could possibly suggest.
Well, my submission is that, as regards the present case, that first of all, our submission is that this doesn't apply in relation to portfolio dividends for the reasons that we set out in our case.
Yes.
But our other submission is that what it cannot do is lead to the conclusion which Mr. Justice Henderson came to, which I'm just going to turn to, which is that you, as a matter of EU law, you take the foreign nominal rate of the company paying the dividend, the Water's Edge company. And that is the correct. That leads from FII number 2, because that's what he decided, and that's what the Court of Appeal upheld. That the starting point is the reference in this case obviously doesn't mention foreign nominal rates. It isn't discussed in it. It isn't part of the decision. So the only way that anyone can get to foreign nominal rates is by applying this decision to portfolio dividends. And we would say, at the very least, it's not that clear, and you cannot decide that you apply this in the way that Mr. Justice Henderson and the test claimants say it should be applied. Can I just take you to what Mr. Justice Henderson said about this
What do
in his
you
judgment?
rely on in, just before we go to Mr. Justice Henderson, what do you rely on in the judgment we're looking at for the exclusion from its scope of portfolio dividends, given the broad nature of the question that's asked in paragraph 36?
Well, it is the fact that it isn't focusing on portfolio dividends, and the earlier cases were focusing on them. This is all focusing on group dividends. That's the whole basis of the argument.
Where do you, yes?
It's a question that was referred back from a case which is all about group dividends. That's what the case is about.
Yes, but they have seen fit to refer repeatedly to Haribone, which was about portfolio dividends.
Yes, for various propositions, my lord. That's right.
Yes, indeed.
Which come. I think in most cases they actually
So it's not so
a
much
repetition
the
of what
words
was in the
used,
first
it's the
reference.
context in which the words are used that we look to create the
But the yes,
qualification you
But-
put in it.
but the propositions that they rely on Haribo for are not directly relevant to the decision the particular decision that we're looking at. For instance, paragraph 53. Is simply a statement of general principle, which was applied in Haribo as well as in FII number 1. Similarly, paragraphs 38, 39
But what
are all general principles that
well, why
come
wouldn't
from
they
that
apply
case.
to portfolios as well as anything else? Why wouldn't they apply as general principles?
Those principles, I'm sure, do. Yes, I'm taking it. What we're taking issue is it was the conclusion that they come to in what is page 2809 when they come to consider the question of justification, fiscal cohesion, and then proportionality. And
Fiscal cohesion means of the tax system in question. Is the tax system in question
It's a
What
UK
is
tax
it?
system.
UK tax system.
Yes.
Well, it's
Yes.
It's a UK tax system we're talking about. Yes, it's a justification that a member state can have to protect its own tax system. So it's saying that there is a rationale for the way that we treat foreign dividends as opposed to UK dividends because of other parts of the system. And that reasoning, my lord, you won't find in relation to portfolio dividends, because you've seen, for obvious reasons, that argument was rejected in the reference in the present case. It was argued that the system, the portfolio dividend system, was justified by fiscal cohesion, and that was rejected by the court.
well, just remind me where that is to be found.
It's in the reference 10, isn't it? And it's well, it ends at paragraph 64. The consideration. Sorry, page 3728, MS 3728. So it begins at paragraph 64 and ends paragraph 68. So this is an argument that was raised both in FI 1 and in this case. This is in the context when they were dealing with the second question and the reference about insurance companies.
But they seem to be accepting or applying the concept of fiscal cohesion in the present case to,
Yes.
to say that the disentitlement to relief in respect of companies with less than 10% shareholding wasn't justified. And similarly, they are applying the cohesion reasoning in a sort of more positive way. They're saying there wouldn't be any problem in relation to fiscal cohesion if you have national rules which exempt and in respect of domestic dividends, but which operate an imputation system in respect of foreign dividends.
That's because in the second reference, we've been looking at the FII reference, they've concluded that there was a direct link, therefore fiscal cohesion could operate. If you look at paragraph 59, there was a direct link between the tax advantage granted and the tax exemption for nationally sourced dividends, and on the other hand, the tax which the distributed profits have been subject. But they held in portfolio in this reference, they held that there wasn't such a direct link. So the reasoning.
Well, except in the next paragraph 60, they say, fine, a direct link exists, but
Yes, but it has.
it's not been operated in a
Proportionate way. Yeah.
Because you are giving the full benefit of a nominal rate of tax, whatever the effective rate of tax in respect of domestic dividends, under the exemption method, that is. But in respect of foreign dividends, all you're doing is taking the effective level of taxation and giving a credit for that, or yes, giving credit for it. And therefore they say you must, in order to balance the two, you must balance.
Take account of the nominal rate.
Take account of the nominal rate. Now, so what's your answer to the proposition that if this applies to portfolios, holdings, as well as non-portfolio, this is an indication that the appropriate rate to look at is the nominal rate? What's the answer?
Well, if it was right that you could apply the same reasoning as this to portfolio dividends, well, of course, you get to the same answer. But that's the very question. Can you apply that reasoning?
You accept the reasoning here, but
I'm not questioning the reasoning in the final.
the sole question is therefore whether there is a distinction. Well, there are two questions that you'd like to argue. The primary question is whether there's a distinction between portfolio and non-portfolio holdings.
Yes.
But there's also a secondary question which you may have problems in relation to permission to appeal about, but we'll come to that, is assuming you are applying the foreign nominal rates, which is the company you're looking at, the foreign water's edge one or the what I call the feeder companies, the companies I think you call below the foreign water's edge.
or
above them, whichever you look at it.
Or putting it more precisely, paragraph 62 of the case, the nominal rate to which the profits underlying the dividends have been subject.
Yeah, that's where you say you get that. So that you may not get support on the first point from this, or maybe you do, but you get support on the second point. Okay.
Yes, but our point on this, I suppose the second point is that it cannot. I'll show you what Mr. Justice Henderson decided, and I would submit he actually decided the whole thing together. We'll see.
Yes.
But in fact, in any event, you cannot support a decision that it is the nominal rate of the Water's Edge company by FII number 2. It simply doesn't support it, whatever.
Right.
Even if we are somehow procedurally unable to say the true answer is not that company, the answer is that it doesn't support, this case simply doesn't support the conclusion that they are arguing for. The only conclusion this case could possibly support is that you apply it to what you look at as the foreign nominal rate to which profits were actually subject. And that's because, as Mr. Justice Henderson explaining in FII, that's because the rationale of this whole thing is that it is the foreign nominal rate that is applying to charge tax. You're in effect topping up, if you like, the actual tax that was paid by the subsidiary or sub-subsidiary, whatever, to the nominal rate. You're not simply plucking a nominal rate out of the air and saying, well, that's a rate, we'll use that and grant a credit for it. The rationale of this whole thing is that the companies that paid tax, the foreign companies that paid tax, were subject to reliefs, if you remember. And if you don't top up their rate to the nominal rate, they lose the reliefs. Whereas a UK company paying to its UK parent doesn't lose the reliefs, because the exemption that's granted is equivalent to a credit at the nominal rate. So that in the UK system, you don't lose the reliefs that the subsidiary gets. In the foreign, where it's a foreign company, you do lose the reliefs. That's the rationale of this whole thing. That's why there's a problem. That's exactly what the test claimants were arguing about in this case. They said there's a problem because they lose those reliefs.
These are reliefs which...
Against tax, loss relief, capital allowances that we have in this country, all sorts of reliefs which lower the effective rate to below the nominal rate. So that the foreign company...
You lose the benefit of them.
Lose the benefit of them, sorry, yes, my lord. Lose the benefit of them because they only get credit for the tax actually paid. And if that tax actually paid is very low because of the reliefs, they've lost the benefit of the reliefs. That's the rationale for this decision. So it cannot support a conclusion that as a matter of European law, that you must take account of the foreign nominal rate of the company paying the dividend across the water in every circumstance. And perhaps I could just show you what Mr. Justice Henderson said about this, because I think it's important. It's in the judgment. And if we pick it up at paragraph 92, this is all under the heading, the heading is on page 3622, the first and second issues. What conforming interpretation should the legislation be given in light of the European Court decisions? Or should it be disapplied? So
Sorry, 3626, is it?
3622 is the heading. This is all under the heading there, and 3626, paragraph 92.
Yeah. Right.
It seems to me, in broad agreement with the submissions of the claimants, so this is after he's reviewed all the submissions on both sides. This is essentially what has occurred. The request for clarification in the second FII reference has produced a fuller and more nuanced analysis by the court of the problem associated with the Case 5 charge on foreign dividends. A crucial part of this analysis is the theoretical assumption that the exemption from taxes of a dividend is regarded as equivalent to grant of tax credit nominal rate. The concomitant principle that a state of residence grants exemption must at least grant credit for the nominal rate of tax paid in the source. So must at least grant credit for the nominal rate of tax paid in the source state, though it remains free to charge a higher nominal rate itself. So this was what the claimants were arguing for, and this is what he has accepted. This flows from the form on the part of the court's general elucidation of the overriding need to treat foreign and domestic dividends equivalently. And then he gives the reasons for that between paragraphs 93 and 96. And he concludes in paragraph 96, the UK legislation would have been compliant with EU law if it provided for the grant of such a dual credit. That is a credit for the higher of the nominal rate in the source state and the amount of tax actually paid.
Yeah, we don't have to go into that.
Don't have to go into that, no, but that's what he decided. Then, if you turn on to page 3632, he then considers what he says in paragraph 107 that he's moving on to factual issues associated with the grant of credit. And in paragraph 108, he makes his decision, or at least sets out more fully his decision on which nominal rate it is. If you just read paragraph 108.
Yeah, so he
concludes
he's against you on that.
He concludes it's the rate of the company paying
State
the
of
dividend.
residence.
The state of residence of the company paying the dividend.
Yes.
The Water's Edge.
That means the Water's Edge company.
The Water's Edge companies, yes. And that's the nominal rates that they have. You'll see, if you read on, you'd see that they've discovered the nominal rates for all those countries.
Yeah.
And can I then compare this? That's what he decided in this case. Can I just show you what he decided in FII when the same issue came up? This is the second time it went to the High Court. It's in Bundle 6, Authority 6, tab 56. And it begins at paragraph 43, page 1936. Paragraph 43 sets out the three possibilities. Beginning with the Water's Edge company paying the dividend. This is the claimant's primary case, you'll see, and their alternative case and the revenues case. And then if you just read the following page, you'll see that his conclusion is that it ought to be the state in which the profits were subject to tax. paragraph 48, he comes to his conclusion on this. That in principle, the appropriate FNR to apply is out of the jurisdiction in which the distributed profits were in fact subject to tax, in preference to a blanket application of the FNR applicable to the Water's Edge company which made the distribution. Consider this solution better accords with the language of the ECJ and with the rationale for requiring a credit at the FNR at all. In the case of portfolio dividends, the practical simplicity of A was conclusive.
So what you've got in your favour is the fact that the expert judge in the field has changed his mind on this.
Well, he doesn't say he's changed his mind. What he says is he can come to a different answer depending on the practical implications of his decision. In other words, if he can come to a different answer in portfolio dividends from group dividends, essentially. He says he can come to a different conclusion, which he has, in portfolio dividends from group dividends, which is FII is about group dividends.
Yeah.
So he's saying the answer is different. Now, we would say it's difficult to see how the answer in principle, which must be a matter of European law, what is required, can be different. But what this also demonstrates is the judge himself coming to different conclusions, determining that the European law principles are different depending on whether it's portfolio dividends or non-portfolio dividends.
Well, now, how do you deal with the point, and when do you deal with the point that apparently, although we haven't seen the document, the Court of Appeal refused permission to appeal to the Court of Appeal, in this case, to you, on this point?
Well,
i.e. it held you, presumably, to looking at the Water's Edge company willy-nilly. And it said by the respondents, as I understand it, that you can have this sort of situation where parties are precluded from raising points which may, in another litigation, prove quite correct.
The main answer to that is, well, we don't have to challenge the decision in this case. What we can challenge is whether the conclusion that they've come to follows from the authority, from the European Court decisions.
Sorry,
they cannot say in the same time the decision is simply that there is a nominal rate. It could be any nominal rate, and that follows from ECJ2, because ECJ2 doesn't say that at all. ECJ2 is very specific in what it says. It's focusing entirely on the nominal rate of the company, the rate of the company where the profits are subject to tax. And the whole, as Mr. Justice Henderson says, not just the language, but the rationale of the decision is all that. So you cannot use that as a support for, even if this is possible, which we would suggest is rather artificial, for a abstract conclusion that you can use a nominal rate rather than a particular nominal rate. You can also see Mr. Justice Henderson's decision. His decision wasn't an abstract one. His decision was, if we go back to paragraph 92, where he concludes on this question, he's not answering the question in the abstract. He's answering the question, can they, this is paragraph 92, 3626. He's saying that
Sorry. Where are we going now?
It's Mr. Justice Henderson's judgment in this case, MS 3626. Paragraph 92. This is his conclusion on the question which we were looking at a moment. Which we are now looking at. Yeah. The question that was appealed to the Court of Appeal and now to this court. He says in the middle of the paragraph,
yes,
a crucial part of this analysis is the theoretical assumption that exemption is regarded as equivalent to the grant of a tax credit at the nominal rate, and the concomitant principle that a state of residence which grants exemption to domestic dividends must at least grant credit for the nominal rate of tax paid in the source state. Yes. The source state being what that means is the state of the source of the dividend. We talk about the state of residence and the source state when we're talking about foreign dividends. So the rate of tax in the source state, although it remains free to charge a higher nominal rate itself. So that, not surprisingly, Mr. Justice Henderson wasn't deciding this question as a matter of in the abstract. He was deciding it on a particular argument, which was you must give credit. This is what was being said by the test claimants. You must give credit for the nominal rate of tax in the source state. And that's what ECJ2 leads you to. And he accepted that. And you can see in paragraph 108, which we've looked at, that he considers it a bit more length. He decides at that stage that is what the decision ECJ2, that's what it decides.
Well, we'll have to look at some point, and I'm conscious that
yes.
you've used quite a lot of your time.
Yes.
But maybe you'll leave it to respondents to object. But we'll have to look at the where you were denied permission to appeal, in
yes.
what terms.
Well, yeah. In any event, those are, I think, given the time, unless there are other questions,
That's your
propose to
to
move on.
Yes.
Yeah. And as far as issue 4 is concerned, I'll obviously deal with that in reply. That's the cross appeal. We've already looked at Haribo, and this is a question about whether European law would say that the situation is different if it's very difficult to provide the information. So,
yes, I mean, you've already covered that by saying European law has a pretty blanket rule, basically hard luck. You ought to have at best made some arrangement in advance to get the information.
And that's subject to an exception, which I'm sure you'll see. My learned friend will take you, no doubt, to a case called Accor, which is a case that Mr. Justice Henderson also dealt with. There's an exception in cases where the foreign law, there's some impossibility because the foreign law prohibits it.
Right.
Yeah, but that's not this case. So therefore, I will, if possible, turn now to the other issues, in particular, begin with issue 5. And could I, as an introduction to this...
I'm sorry. Just before we leave that first issue, can I just be sure I understand how the answer to this first issue affects the respondent's claims?
The position is, as I understand, the evidence which they produced at the trial was only evidence on the foreign nominal rates of the Water's Edge companies.
You say it eliminates them, effectively, doesn't it?
In this particular case, yes. Obviously, as I mentioned at the beginning, other claimants may well bring evidence of whatever it is they have to prove. But Prudential themselves only brought evidence of the rates, the foreign nominal rates of the Water's Edge. That's the only evidence that they brought. And that's why they're also arguing alternatively that that's enough. That can be a proxy or something for the actual tax paid. That's the position in Prudential. As I say, with other claimants, it all depends on what they can actually prove if they're told that that's what they actually have to prove.
But if we were to uphold your submission that it isn't clear from FII ECJ2, are you in fact asking us not to decide but to refer?
I'm asking you to refer.
Yes, so you don't in fact want a decision from us at this stage. You just say all we have to decide is, does FII ECJ2 cover this case? If it covers the case that we get
precisely, if it covers it precisely, then there's no argument.
If it doesn't, then
if it has that effect.
Refer.
Yeah. And if you're referring, of course, you'd be referring issues on portfolio dividends, which will probably include questions about difficulties and possibilities, etc. I would imagine how it applies in cases of portfolio dividends, which is something that wasn't addressed in FII, because obviously we weren't dealing with portfolio dividends there.
I think my question was a simpler one.
Yes.
It was just to be sure I understand how the answer to this first question affects the claim, in the sense that the claim is for effectively the repayment of overpayments of tax. So how does this first question affect it?
Because it comes in, if you remember, my lord, I set out the sort of 4 stages. Yep. It comes in at the very first stage, because you then it comes in at determining what is the unlawfulness and what conforming interpretation ought to be applied.
Well, does it affect is the point that it affects that you need to have this answer in order to calculate by how much the tax
Yes.
was overpaid.
Absolutely.
Yes.
Yes. You have
So
to,
that one is not looking. The question by how much the tax is overpaid will then, the answer to that will determine the amount of the restitution.
yes, exactly, my lord. And that, in fact, is just what I was going to turn to. What Mr. Justice Henderson said about this, he explains, I think, in this decision, in the Prudential decision itself, how this works.
Yeah. And the reason I was asking was there was a sort of risk of losing track of what we're really dealing with here.
Absolutely.
And we, they can't recover tax they haven't paid, but very simply.
Yes.
And so it isn't that they're trying to recover nominal tax that they didn't actually pay.
No.
It's rather that it affects the exemption to which they say they should have got from paying taxes in the UK. Is that right?
So the way it works is this, my lord. They were charged corporation tax on the foreign dividends. They say
Deduction.
there was a deduction for withholding tax,
except for the withholding
withholding
tax,
tax in this case, but nothing else. They say that was an unlawful charge, and the question is, was it, to what extent and in what circumstances was it an unlawful charge? And so, if it was unlawful, insofar as the nominal rate or UK tax was equal to or less than the foreign nominal rate, then that's one thing. That's what they've been able to show so far. They've been comparing the nominal rates, and that leads you to the conclusion that a certain amount of corporation tax was unlawfully charged at a certain time in the particular case. And then, of course, questions arise as to what the effect, what the consequences of that are.
Yes.
But this is the very first stage in the argument. Lord, yes.
Thank you.
And it's paragraph in the judgment of the judge.
Electronic?
Tab 7, it's page 3648.
Yeah.
And paragraph 163 this is under the remedies heading. In the event there's a large measure of common ground in relation to the claims which I have found, where I have found that either corporation tax or ACT was unlawfully levied. The revenue did not dispute that such claims are characterised as San Giorgio claims under EU law. B, the overpaid tax or its time value in the case of utilised ACT is in principle recoverable by either a Woolwich or a mistake claim.
It's only the overpaid amount, the amount
So that's the amount
above what they should have paid had they been given a proper credit.
Exactly, that amount. If they've paid it, that's unlawfully charged and can be recovered.
Right.
And also, as far as ACT is concerned, if it's been utilised, that's another factual issue, but if it's been utilised, then they have a claim for the time value of the ACT between the time it was paid and the time it was utilised against lawful corporation tax. Because at the point it's utilised, it becomes lawful in a sense because it discharges an actual liability to tax. So they're entitled to the time value of that period, and that's SEMPRA. That's directly what SEMPRA decided. And then he goes on to say, this common ground covers the claims to recover unlawful corporation tax, which I have upheld in sections 6, 8 and 9. I've held that the claims to recover tax credits in respect of FII fail. No question of remedies arise. But he says they sound in damages anyway. As to the ACT claims, it is agreed, A, the unlawful ACT which is utilised against lawful MCT is recoverable on the same basis as in Hurst or SEMPRA. B, unlawful ACT which is utilised against unlawful MCT is also recoverable on the basis that the purported charge was a nullity. That has always been common ground and has been the way that these things have been calculated in all of these cases.
Well, both A and B? Or just
Both
B?
A and B, yes. But B in particular, which is relevant to some of the issues today. Because what that is saying is where you've got unlawfully charged ACT, you've computed that using whatever method we've decided under A, under the first principle, once you've got unlawfully charged ACT, if that was then utilised against unlawful corporation tax at the time set off, that's treated as a nullity. There was no set off, because the purported charge to corporation tax was a nullity. There wasn't actually a liability to corporation tax at the time. So the unlawful ACT is treated as continuing to be outstanding and is recovered in full by way of restitutionary claim. So
It's a slightly odd way of looking at it. Isn't there another way? You could say that, yes, the ACT is unlawful when charged, so you recover the whole of that, and its utilisation against unlawful MCT simply means you pay less unlawful MCT, and you recover the actual amount of unlawful MCT that you pay after the
Well, you couldn't recover both.
No, you can't recover both. No, you have to. You get the ACT which you paid unlawfully, and you get the net MCT which you paid unlawfully.
Well, if there was some paid, yes.
If there was some paid.
Yes. Sorry, we're assuming. Yeah, exactly. So let me take it in stages. If there's an unlawful charge to ACT and it's never set off in any way at the time,
You get the whole lot.
you get the whole lot back with interest, whether that's compound or simple.
Say £100, yes.
Yeah, you get £100 back. If the ACT, though, is set off against lawful corporation tax, you don't get £100 back. You get the time value of the period from payment to set off, which might be 5 in your example, and you get interest on that from the time of set off. However, if the unlawful ACT was set off against something that is now recognised as unlawful corporation tax, i.e. it was unlawfully charged at the time, there's no set off regarded, and you get the 100 back.
You get the 100 back, and if you paid any further MCT, you get that back.
Exactly.
That's unlawful too. Yeah.
Absolutely, yes.
And if you did, that's right.
But the point I'm making...
So why did you get the ACT back? You never paid it.
No, you did pay it. Sorry,
You did pay it.
you
Paid
paid.
originally.
You paid unlawful. You paid an unlawful charge
Oh,
to
I
ACT.
see.
You then purported. It was thought it was set off against a charge that turns out to be unlawful itself.
Yeah.
So what
What
happens is you get the whole of the ACT back, because there was never any actual set off. That simply didn't happen, because there was no liability to corporation tax to set it off against. That's the theoretical underpinning of this.
So A and B are really common ground, and
The common ground, yes.
what about C then?
And C, well, that is issue 3, my lord. Lawful ACT, which is utilising as unlawful MCT, is recoverable because the Code of Appeal so held in FII Code of Appeal. This is subject to the Revenue's pending application for...
Would the ACT have been recoverable just under domestic law in the event that there turned out, for whatever reason, to be no liability to mainstream corporation tax?
No.
So why is the position different in the context we're talking about?
It's recoverable. It's only recoverable because the initial charge to ACT was unlawful. If the initial charge was unlawful, then it has to be paid back, because they could have brought an action.
That I understand.
Yeah.
But it's unlawful for a reason other than the non-existence of the liability against which it fell to be set off.
Yes. Yes. It's unlawful because of the principles from the European Court decisions that actually charging ACT in respect of the onward distribution of foreign dividends is unlawful to some extent. This goes back to Lord Reid's point that you didn't get any FII credit where you got foreign dividends. That's the underlying, if you like, problem. And that can lead to the conclusion in certain cases that the ACT was unlawfully charged at the time. But we have to accept, for the purposes of this stage of the analysis, that there was certain ACT that was unlawfully charged, and there was certain corporation tax that was unlawfully charged. That has to be determined at like an earlier stage of the analysis. At this stage, we're then working out what's the consequences, and what do you get back, essentially. So you can see there that there are various principles that have to be applied in deciding what is to be taken to have happened in the past, when at a time when nobody had an inkling of any of this. And issue 5, going back to issue 5, is part of the process of determining that. So if we just turn to what issue 5 is, so issue 5A, where there's ACT in a pool that includes unlawful and lawful ACT, and it's utilised against an unlawful corporation tax liability, do you regard, for this purpose, as it to be utilised pro rata, or do you decide, for some reason, that the unlawful ACT should be a prepayment set off against the unlawful corporation tax first? And the Court of Appeal held that there was no reason to displace the normal kind of presumption that where there's a mixed pool and that you cannot determine what has actually happened, that it happens pro rata. And that is also what, as a matter of interest, Mr. Justice Henderson decided in FII number 2. I'm not going to take you to that, but you'll find it Authorities tab 6, MS 1974, paragraphs 205 and 211, when he considered this exact very issue in FII.
And he
decided that pro rata was the correct approach, and there was no appeal pursued on that issue before the Court of Appeal in that case. Now, the test claimant's way of dealing with this is to produce calculations, which your lordships will have seen, which attempt to show that the methodology, the pro rata methodology, produces results which one wouldn't expect. We would say this is fundamentally the wrong approach. What they do in their examples is to assume what they think the answer ought to be, and then to demonstrate that it doesn't produce the answer that they think it ought to. For instance, they assume that the full amount of corporation tax which was unlawfully charged, as opposed to paid, must be returned. And they set that out at their case at paragraph 170.
What if ACT has been...
corporation tax is unlawfully charged but not paid. They assume that the correct answer must be that the whole of the charge must be returned, they say.
Well,
even though there was no payment.
Rather than the net amount after set off of the law.
Rather than the amount that's actually paid, exactly.
Yeah.
Yes.
Well, yes, I can see the problem about that. The fact is that the ACT is, yes.
But we say
is due and paid.
Fundamentally that the assumptions which they make are simply not justified. They're simply self-supporting assumptions.
Is that the only one which you question?
Well, what they also attempt to say in relation to this is that, essentially, that some of the ACT must have been unlawfully charged. In our example, but we would say that's not correct. We would say what the test claimants say in their case. If you just turn up their case briefly at this, at paragraph 170. Which is MS 3485. We would say that is not correct. They say that this is our calculation, this is the revenues method. They set out on paragraph 169 what the revenues method produces, which we say, we've set this out in our reply case, we say it produces exactly the result you'd expect. But they say this doesn't achieve the result which EU law requires, namely the return of the £25 of unlawfully levied MCT. This wasn't, £25 wasn't paid in the example, but it was charged. And a time value claim for the £18.75 of unlawfully levied ACT, tax paid too early. The outcome in the HMRC's approach is the unlawful MCT of £25 is reduced by half. Well, the answer to that is that is all that was actually paid.
Well, yes.
All that we're saying is that you can only claim restitution, a return of tax you actually paid, not tax that you were charged.
If you have ACT, lawful ACT of £100, and you have an MCT bill of £300, which is unlawful, the whole of it.
Yes.
It's reduced by the £100 lawful ACT, so you pay net £200.
Yes.
And you say
that's what you
can't
can
recover the ACT, or you shouldn't be able to recover the ACT, and you should be able to recover the £200.
Yes.
Yeah.
But there's no reason why you should be able to recover the £300
Right.
if it wasn't paid.
I see that. Is that what has somebody said that you
Well,
could recover the £300?
But what they say in paragraph 170 is it's not 300, but they say this doesn't achieve the result which EU law requires, namely the return of the £25 of unlawfully levied MCT. Unlawfully levied, that is, not unlawfully, not paid.
Yes.
So that's when you look at the examples, you'll see that isn't the amount of tax that was paid. That's the amount that was charged.
So the tax overpaid beside it is muddling the concept.
Yes.
Yes.
Yeah. So essentially, the examples don't prove.
They don't work.
They don't prove anything. We would say.
Have you got?
And as regards 5B, 5B is a slightly different question. This is about a very, very abstruse question about carrying back FII within an accounting period from one quarter to another. The flaw in the argument there, again, we say it should be done on a pro rata basis. That's what the Court of Appeal decided. The taxpayer's argument is that what we say should be taken as happening wouldn't have happened under the UK system. And that's paragraph 181.3. And all I'm going to say about that, I think I ought to move on now to more important issues, but all I'm going to say about that is that the analogy in paragraph 181.3 is simply not a good one. Under the domestic system, as we have seen, there wasn't a liability to ACT against which FII is applied, which is what they suggest in paragraph 181.3. ACT was always charged on the difference between frank payments and franked investment income.
So sorry, there wasn't a liability.
There wasn't a liability to ACT, which was then reduced by a credit for FII. That's not the way that the system worked. ACT was charged on the difference between franked payments and franked investment income for a quarter. If franked investment income was carried back from a later quarter to an earlier quarter, that increased the amount of FII in the earlier quarter and therefore reduced the difference between franked payments and franked investment income and reduced the liability to ACT, but that's how it worked. So there's no question of setting one credit against another, which is what the taxpayer seems to be alleging in this paragraph. I shall return to that briefly in reply if necessary, depending on what the government says.
Might you at some point put your answer in writing?
They are in writing. It is in writing.
Well, is it precisely? Well, I must have.
We submitted something called the appellant's response on cross appeal.
Yes, I've got that, yes.
It's set out in there.
Just...
It's under issue 5, begins on page 13.
Right, yes.
So it's all set out. Paragraphs 28 to 33 is what I've just been
Yeah.
saying.
We've overlooked that. Thank you very much.
Right.
So can I now turn to perhaps a more interesting issue, which is restitution for time value.
Where are we in your printed case now?
Now, issue 2, yes, it's MS 3389.
Right.
And we're now in the position, after after the decision of this court in Littlewoods, that there is no EU aspect to this issue in this case. It is entirely a question of the law, the English law of unjust enrichment. Prior to Littlewoods, of course, there was always the problem that whatever the English law said, there was potentially a Euro light,
right.
but that's gone now. And that is, as we agree, that's how Mr. Justice Henderson approached it at first instance. He approached this as a matter of domestic English law. And we're concentrating here mainly on questions of mistake. The principles, whatever principles you decide should be applied, must apply equally, whether the defendant is a government department or a private individual or a company. This is not a decision which is related solely to the revenue. It must also apply equally whether the defendant has some way been responsible for the mistake or whether the defendant was entirely innocent and has received a payment by mistake entirely by the fault, for instance, of the claimant, which he then retained in good faith. We said in our case this is the first time that a court has recognised the decision of Mr. Justice Henderson at first instance, the first time that a court has recognised a purely English law cause of action in unjust enrichment for the time value of money retained by mistake. That is, of course, subject to what is decided in Sempra, but this is the first time that principle has been extended and recognised.
Did Mr. Justice Henderson put it on the basis that this is a common law cause of action? Because I seem to remember being in the minority in Sempra and thinking that it was with Lord Walker, perhaps?
Yes.
That it was
there are a number of
equitable.
minorities in Sempra, yes.
And we lost out on that, did we? Because we thought that equity would treat it in a slightly discretionary way, whereas query what the common law does.
Well, I'll come on to what Sempra decided, but certainly Lord Hope and Lord Nichols dealt with it as a common law claim for restitution. Yourself and Lord Walker dealt with it as a claim in equity.
And Lord Scott?
And Lord Scott dissented and decided that it wasn't a claim at all. But he decided, I think he's regarded as being the majority on this, he decided if there was a claim, it would be a common law claim. So the majority for a common law claim is a slightly tenuous one. It's based on the two of them and Lord Scott, who didn't agree with their analysis.
We count heads in relation to each issue, do we? In common law precedent.
I will take you in a short time, very short time, to the Sempra and the head note, which is particularly interesting. Prior to Sempra, everyone simply understood that there was a claim under Section 35A for interest, which followed on from a claim for principal sum. So if you claimed restitution, got the money back, you got interest under Section 35A. And that's what happened even in Woolwich, if you remember the Woolwich case, where the whole case was about interest, in fact. The only reason for bringing the case to the House of Lords was to obtain the interest, because the principal sum had already been paid back by the revenue. The revenue said they paid it back as a matter of grace, and Woolwich said no, they had a right to it. But the reason they were establishing that was so that they could get the interest. But they got interest under Section 35A, as you can see from the decision. In the swaps cases, which were the other lines of authority where restitution has been developed most recently, in West Deutsche, there was an attempt to claim compound interest in equity, which failed, you recall, my lord.
Again, by a majority, didn't it?
By majority, yes, that's right. And I think in Sempra you would have been inclined to overrule West Deutsche.
Yeah.
And even in Sempra itself, the category, what we call the category C claims, that is the claims for interest on the Sempra amount, were rejected by Mr. Justice Park, and the claimants didn't think it worth even appealing that to the Court of Appeal. So there was no issue before the Court of Appeal or the House of Lords on the interest on the Sempra amount, if you recall, my lord.
That's interest on the
interest.
monies which had been utilised.
Yes, that's right. So what we're arguing about today
Yeah.
are what Mr. Justice Henderson referred to as the Category B and the Category C claims. Category B claims are claims where unlawful tax has been paid unlawfully and is now being recovered in full, and the claim is for interest on that from the date of payment till the date when it's repaid under the judgment. And the Category C claims are claims in respect of Sempra amounts, that is where the ACT was paid, unlawfully paid, but then set off. And an amount then is crystallised, being the time value claim between those periods. And the question is, can interest run on that?
Yes, we see that set out in Justice Henderson at paragraph 194.
Yes, and we set that out in our case as a sort of introduction. That's the basis of the analysis.
Yes.
Now, Mr. Justice Henderson's conclusions on this, you can find between paragraphs 241 and 247 in his judgment. Which which is page MS 3684.
Right.
Where he deals with these various claims. Now,
I mean, the critical concept is that he finds interest as part of the restitutionary claim itself, and therefore you don't get into 35A at all, he said.
Yes. So he's recognising a claim in restitution, in unjust enrichment, for the time value of the holding the money.
In B and C as well as
in B and C as well, yes.
Yes.
But
And you say that goes beyond what Sempra required him to do?
we would say it went beyond what Sempra decided, and it's wrong in principle for a number of reasons, which I'll briefly, I think now, develop. But what I'd like to also show you, well, can I make the first point to make is in this particular case, in Prudential, there was no evidence one way or another as to the government's position. Neither the claimants nor the revenue put in evidence. So the claimant's case was based on, if you like, a conventional basis, that they were entitled to under this unjust enrichment claim, they were entitled to interest, almost by presumption, they were entitled to interest. They didn't have to prove anything, apart from the fact that they paid the money, which was unlawfully charged, and they were now entitled to get it back. They didn't have to prove anything further than that.
No, it's an assumption that the government will use the money to its benefit.
Yeah, there's an assumption of something. Yes, there's an assumption that there is an interest entitlement, certainly, as a result of that. And that's the basis of the decision that Mr. Justice Henderson made here. In Littlewoods, where there was a parallel issue on compound interest, Mr. Justice Henderson made his position clear, even starker. This is Authorities Bundle 3, tab 38, para MS 997. Where he says at paragraph 413, having considered the expert evidence and the views of Mr. Justice Voss in Littlewoods number 1, I see no reason to depart from the initial conclusions which I drew from Sempra and Benedetti. In my judgment, the benefit to the government from the overpayments of VAT is, as a matter of law, correctly measured by the objective use value of the money, which translates into an award of compound interest computed in accordance with Professor Kay's rates and methodology. The actual use made by the government of the overpayments and the actual benefit which the government derived from them are, in my opinion, irrelevant to the objective measure thus ascertained. And he then goes on, because there was evidence in this case as to what the actual benefit was. He says, if contrary to my primary conclusion, it's open to the government to establish and rely on the actual benefit which derived from the overpayments, I consider the government has succeeded in showing on the balance of probabilities that the saved interest on the principal amounts of the overpayments was absorbed in government expenditure in the fiscal year following the year of receipt of the overpayments, and therefore did not further reduce government borrowing. So what he's deciding is, as a matter of fact, in this case, it was shown what the actual benefit was, but that is irrelevant. He was deciding starkly, as a matter of law, that you're entitled to interest on an objective measure, regardless of the actual benefit to the defendant. And that decision was appealed in Littlewoods. And the Court of Appeal came to a slightly different conclusion on this issue. You can see that tab 30, the following tab, MS 1065, where it begins on 1065, paragraph 183. And the conclusion on this point is on MS 1067. Paragraphs 192 and 193, first of all, where they conclude that the starting point ought to be an innocent recipient of overpayment should not have to make restitution of more than he actually received, not knowing it was an overpayment, unless he freely accepted the benefit of having an overpayment and the obligation to pay for it at market rates. And then he derived that from Benedetti and from what Professor Burrows said. But then they conclude in paragraphs 194 to 198 that this doesn't apply in the case of the revenue of the government.
So they uphold an objective use value.
Yes.
It seems to be. How do you relate this back to Sempra, where I thought that there were?
Yeah.
I mean, Sempra would support this, but I think, but they don't seem to rely on Sempra, the majority view that you look at it objectively.
Well, there's nothing in Sempra which corresponds to paragraphs 195 to 197, because there was no consideration of any of that in Sempra. And we would submit, for the reasons we set out in our case, we would submit that that's simply wrong. It's not a correct approach to this. We've set that out in detail in our case. What we say, we say two things you have seen from our case. One is that if there is simply a right to claim an objective amount without any proof of benefit, etc., then that is in substance a claim for interest. And that claim, simply a claim for interest, and that claim does clash with Section 35A. And it clashes with one of the cardinal principles in Section 35A, which is that the claim is, under 35A, is for simple interest. So if it's simply a claim of that sort, we would say that does clash with Section 35A. But what it could be is a claim which requires the claimant to prove the actual amount of the benefit, to prove an actual benefit conferred on the defendant. Not a presumed benefit, but an actual benefit. We are, you again got to remember, we're not talking about compensation. It's nothing to the point to say that, for instance, Prudential or Littlewood suffered loss because of this money having been paid to the revenue. That's not relevant to this type of claim. This type of claim is in unjust enrichment. It's asking what benefit has been conferred on the defendant, which ought to be reversed by unjust enrichment. And we say that the benefit that you might allege, for instance, might be that it resulted in a saving of borrowing costs by the revenue, for instance, or any defendant. But we would submit that's a matter that has to be proved, or alleged first, obviously, but then proved by the claimant. Not a matter that can be presumed, because, as I say, if we are presuming something like that, we are simply, in essence, granting a right to interest, which does conflict with the statutory provisions that have been around for quite a long time.
Isn't that contrary to... No, I suppose it isn't contrary to Sempra, because
No.
Sempra wasn't dealing with a situation where the statute could apply.
No, the point about Sempra, I was just going to come to Sempra.
Yes.
I mean, the point about Sempra was, this was, first of all, it was a claim which didn't exist in English law prior to Sempra. That was the problem that the claimants had. One of the reasons why they referred a question to the European Court, if you remember, Metal-Gesellschaft. One of the questions was, can the national authorities say, because of a rule in the national law, the Pintada rule, put it shortly, that you cannot claim simply for interest where there's no principal sum.
Right.
Because, of course, this was a claim at a time when there was no claim for principal sum. The principal sum had been repaid by set-off.
Right.
So there was no claim under Section 35A in Sempra, because there was nothing to attach it to. So Sempra was all about that situation. It was a claim where there was no other claim. There was something required by European law. And as we've set out in our case, all five judges, all five law lords, referred to the fact that these were claims that were required by the European law, the Court of Justice.
We undoubtedly went much further and discussed common law and equity, didn't we? And isn't there a majority in Sempra for the proposition that the starting point should be conventional rates and an assumption of compound interest?
Well, shall we look at shall we look at Sempra now?
Maybe that is going too far, but
it's tab 5. Yes. I think that's going too far, because, put shortly, it may be that Lord Hope and Lord Nichols seems to agree on that, although there are certain differences between them.
Which volume are we in?
It's volume 5.
Lord Walker simply agreed with compound interest,
But Lord Walker's rationale for it was quite different, which was it would be granted under equity, and he said it would come to the same thing, because the exercise of the equitable jurisdiction would result in the same result. But there is no majority in any real sense for any rationalisation of the decision. It's tab 52. What there is a majority for is the first decision which Lord Nichols made, which was that you could recover in damages in interest if you could prove loss. Now, that was an important decision, obviously, and was overruling, in a sense, the Pintada. There's no doubt that decision is there, but that is, of course, a case where you have to plead and prove your loss. So Sempra, it's 1454. And if you just read, rather than reading don't read the first part of the head note, because but if you read the held, you can see the various different combinations that have to be found for the various decisions. So yes, you can see from that, which I would suggest is a reasonable summary of what was decided on the various issues. What there is a majority for is that Sempra were entitled in that case to compound interest at a conventional rate to reflect government borrowing. But how you got there was quite different between Lord Nichols and Lord Hope on one side and Lord Walker. And can I give you, rather than taking you through them, can I give you references to what I would say are the key parts of the judgments of each of the 5 judges, which encapsulate what they decided? Lord Hope, paragraphs 46 to 49. Lord Nichols, 116 to 119. Lord Scott, 146 to 153. Lord Walker, 183 to 188. And Lord Mance, 231 to 241. And perhaps I could just take you to Lord Walker, because he is if you like, the majority swing vote. And pick it up particularly at paragraph 184. Where he says, Lord Nichols and Hope proposed to cut through the thicket of problems by recognising a restitutionary remedy available as of right at common law, subject to the court's power to resort to subjective devaluation in order to avoid injustice in hard cases. This would be following a course which in West Deutsche was not as much rejected as assumed not to be open. I must confess that my own inclination would be to take the course which this House has come very close to taking, but ultimately drew back from taking in the West Deutsche case, that is to extend the court's equitable jurisdiction toward compound interest. Before your lordships, the law has been much more fully investigated. There are compelling reasons for departing from West Deutsche case. And then he goes through what was said by Lord Gough and Lord Wolfe in paragraph 185. And then 186, in West Deutsche, Lord Gough and Lord Wolfe both considered at 691 and 723 respectively, that on the facts of that case, compound interest was required in order to achieve complete restitution and reverse unjust enrichment. Lord Wolfe recognised the exercise of the auxiliary jurisdiction would, as with all equitable remedies, be discretionary, that compound interest would not be awarded if the facts were such the defendant would not have earned compound interest. Awards of simple interest under Section 35A of the Supreme Court Act are also discretionary, but the court's discretion causes few difficulties in practice. In my opinion, this is clearly a case in which the compound interest should be awarded since, and these are the factors he took into account. One, it is a case where community law requires full restitution, so that, again, an important factor. Two, the defendant is economically powerful and sophisticated, must be supposed to have taken full advantage of its premature receipts of ACT. And three, it's not suggested that the claimant has been at fault or been dilatory in making or pursuing its claim. These are all, I would submit, not factors that would be taken into account or would be relevant in a common law claim in unjust enrichment. The fact that the defendant is economically powerful and sophisticated wouldn't be a reason, in my submission, as a matter of principle, for assuming that he took full advantage of the premature receipts. And similarly, the fault or dilatoriness of the claimant is not relevant in unjust enrichment. Indeed, there is quite clear authority to that effect. But these are the factors that Lord Walker was taking into account. So you can see, although Lord Walker says in paragraph 188, the both routes lead to the same conclusion in this case, it cannot seriously be said that Lord Walker is part of a majority for a common law claim of any kind for unjust enrichment.
Yes, he said in the previous paragraph he feels apprehension about the suggested conclusion that compound interest should be available as of right.
Yes.
The discretionary nature of the equitable interest provides the necessary flexibility. Yeah.
And in Sempra, the House of Lords were not considering, we know the category B and C cases, they weren't being argued. There were in fact no category B cases at all in that case. They were all cases where the ACT was set off factually, but they weren't considering even the category C cases. So what we say about it is that you either should recognise an action in unjust enrichment at common law, which requires the claimant to prove the elements, i.e. that the defendant was enriched in the relevant sense, i.e. in this case he was enriched by having been released from having to borrow. He didn't borrow amounts because of the payments. And that would be the case not just with government departments, but with individuals and companies. It must be open, we would submit, if someone were, for instance, to pay £5,000 by mistake to a large multinational company, it must be possible for the company to say, okay, you've paid us this money, we have to pay you it back. But it didn't result in us saving any borrowing costs. The borrowings that we made were completely unaffected by this very small amount of money that you paid to us.
That's the point.
And therefore,
by putting it that way around, you've accepted that the onus would be on the defendant to do something, but it may be only an evidential onus.
No, I'm only saying that would be their response to a claim. There would have to be a claim saying you have been saved borrowing costs by the payment. How can a
claimant know that? I mean, the reality of the situation is that it would be unrealistic to place a legal onus on the claimant. How would you find out? You'd have to get discovery in advance of the action and investigate the whole of the defendant's finances. The more acceptable situation might be to say that there is a natural presumption that the defendant will have used the money fruitfully, unless the defendant rebuts that. That's an evidential. At the very least, it's a legal onus shifting to the defendant, but to put the whole onus on the claimant seems to me rather unrealistic.
Well, it's not. There must be an onus, at least on the claimant, we would submit, to raise the issue. Exactly. What are they alleging happened? They may not be able to.
Well,
prove
all
it,
they
but
have to do surely
allege.
is say, we make a claim for compound interest, and we assume that you put the money to good use.
Yeah, well, again, with
the
respect, putting the money to good use is not really the issue. I mean, what they did with the actual £5,000 in my example wouldn't be relevant. This is not a case of disgorgement. We're not tracing the amount. The question is, what benefit are you to be taken to have transferred to the defendant by transferring this £5,000?
Yeah.
Now, the benefit wouldn't be what the defendant did with the money. They might have used it, in fact, used that £5,000 and made a lot of money with it, but that wouldn't give the claimant a right to claim that profit back. All they could say is there's been a benefit to you by this transfer. The fact that you had this £5,000 sitting in your bank account or whatever, there's been a benefit to you, but you must identify what you're saying that benefit was. You can't simply say, we would submit, you can't simply say, we assume that you'd be benefited by it. You've got to prove otherwise. Otherwise, the defendant's then put in the position that he doesn't know what's being alleged of him. He's got to prove every possible way in which he
knows
might not
perfectly
have
well
benefited.
what's being alleged is that he's had the use of the money, and he's the only one who knows what use he's made of it.
Again, the question is, I think, my lord, what is meant by the use of the money? Certainly the money has been transferred to him, but are we looking at what he actually did with it, or are we looking at what would have happened? What would have happened if he hadn't had the money? Which I think I would submit as a more relevant question. I.e., what would, in my example, the multinational corporation have done differently if it didn't have that £5,000? And the answer to that may be nothing. It wouldn't have made any difference one way or another.
Well,
I think it's important to pin down exactly conceptually what it is we're asking, because there is a tendency in this area to ask these kind of questions. What do they do with the money, etc. Where I would not submit that is the correct question to be asked.
Well, that's why it may be the Court of Appeal's approach is quite realistic. They said you assume they did something useful with it, and even if they didn't, presumably they thought doing nothing was useful.
Well, they did something extra with it.
It's traditionally an entirely notional exercise. It's not, so to speak, an inquiry as to damages for not having the money.
Well, that's why I say, my lord, if that's right, it is a purely notional exercise. It is actually, in substance, just a claim for interest. It's not truly a claim which goes beyond that. It's not truly a principal claim for anything. It's just a claim which is based solely on the fact that money was paid by mistake to someone, and the inevitable consequence of that is that you have a claim not only for the money back, but for some kind of time value, and that is we would submit simply a claim for interest, which would clash, we would say, with Section 35A, and you wouldn't have the point that could be made in relation to other claims that there is a principal claim of a real sort.
Well, coming down to that point, in the present context, you say that once the ACT wrongly paid has been utilised by being set off, the claim is crystallised, and thereafter you get simple interest. But that is a situation where, on the face of it, the loss is less grievous than the one where the ACT can't be utilised, wrongly charged, can't be utilised at all, and yet you say that there they only get simple interest the whole period. So, very odd, isn't it?
I'm sorry, but you say, well...
They get, you say, in that situation, if it hasn't been utilised, they get simple interest from point one up to date. Whereas if it has been utilised, they get compound interest in respect of year 1 to 3.
Yes.
If it has not been utilised, then you get simple interest years 1 to 10.
Yes, but that, my lord, is a function of, first of all, the fact that there is statutory provision, Section 35A, governing that situation, whereas there was no statutory provision governing the SEMPRA situation. That SEMPRA situation arose because of a European court decision requiring you to have a remedy in a particular situation that wasn't covered by English law. So that's why that, if you might say, anomaly arises in the present case. But there is a second point, my lord, which we have, you may have from our case, in relation to the Category C claims.
Yeah.
That is, claims where you did the ACT was paid and then set off, and which crystallised an amount of time value for that period. Because what we say about that is applying principles of unjust enrichment. At the time when the set-off took place, the original transfer, which was the enrichment, was reversed. And you can't say that from then on that there was any transfer of value from which the time value claim would derive. We've set that out in our case. And we rely in particular
So
on...
it must be a European law claim, nothing more. Is that right?
If you're claiming for that period, well, you'd claim under 35A, obviously that's available, but you couldn't make a claim in unjust enrichment for that period.
I see, yes.
And we rely particularly on a recent decision of this court called Investment Trust, which I think at least 4 of your lordships were involved in. It's in Bundle 3, Authorities Bundle 3, tab 34.
Tab
34. Yes. This was an indirect recovery case. I think your lordships will, those who were involved may remember, apart from Lord Sumption, who wasn't one of the court in this case. This was a case where VAT was paid, was wrongly charged on the managers of investment funds. And it was paid by the investment funds to the managers under their contracts, and then was paid on by the managers to the revenue. And there was a period, for various technical reasons, which the managers couldn't recover the VAT, and the funds brought claims against the revenue and unjust enrichment for those periods, saying that they had paid VAT by mistake to the managers who should have been paid on to the revenue, and that they ought to be able to recover it. And Mr. Justice Henderson and the Court of Appeal upheld those claims, but this court reversed it. And it's in particular the general discussion, Lord Reid giving the unanimous judgment, beginning at paragraph 37, where Lord Reid discusses the question of transfer of value and what that means at the expense of the claimant in this context. The discussion goes from paragraph 37 to paragraph 45.
What are we looking for?
It's in particular what he says in paragraph 43 as to what at the expense of means. So what we say about this situation is, once the ACT has been set off, the position then is that the claimants had an immediate claim in unjust enrichment for the amount of the time value between payment and set off. And any interest that's being paid thereafter is being paid because that claim hasn't been met. In other words, the revenue haven't paid the claim in unjust enrichment. The transfer of value has been reversed by the set-off. The transfer of value was the original transfer of the money. So there was a transfer of the money, the ACT, to the revenue. That was reversed by the set-off. And thereafter, the claimant is in no different position from any other claimant who hasn't been paid what he's owed. That's essentially what we say, so that there isn't, in principle, a claim in unjust enrichment for that period. So that's a discrete point we take in relation to the category C claims. We say that in principle there isn't a claim. There can't be a claim in unjust enrichment for the period after the set-off of the ACT, because the elements which are required are simply not there.
What at the end of the day are you asking us to say about Sempra Metals?
I'm asking you to say that it doesn't govern the issues that we're dealing with today.
We're not asking to say what it does decide.
Well, what it does decide, I can tell you, it decides, first of all, arguably this was obiter, but it's certainly been accepted as being a binding decision. It decides that there is a claim in damages in respect of interest if you can prove a loss of an interest type, and La Pintada doesn't stop that. It also decided that in that particular case, Sempra was entitled, on various bases, though, to interest for the period between, for the claim that was required by European law for the period between the payment of ACT and its set-off. But that was on two different bases, which was said to come to the same thing. And what it also didn't decide, we would submit, is anything about the burden of proof. It's clear from what Lord Hope says that there was no argument about the burden of proof. He suggests one solution, but there's certainly no majority for anything.
You're also saying that there isn't a clear majority for the proposition which found favour with Mr. Justice Henderson, that the payment of interest in those circumstances was part of the restitutionary claim.
The payment for the periods after that wasn't decided. No, specifically they said there was no argument about that in the case because there was no appeal on the category C. So,
but I think there were obiter dicta by one or two of the judges which might give rise to a broad...
Having had no argument about it, they suggested it, yes.
Yes,
that's all.
But you say there is no majority there.
Absolutely.
And that is why the revenue are not challenging the authority of Sempra.
Exactly,
in this case.
Yes.
Yes, okay.
And you're asking us to approach it on the basis that the Section 35A applies on the footing that we're dealing with the recovery of a debt.
Yes, that's right, my Lord.
I think that's not...
Yeah,
that's been decided.
Yes, but that's covered by Sempra Metals. Yeah. But the point I was really going to ask about is, you're asking us to treat the debt as being the amount of tax overpaid, rather than the any element of interest being itself a debt on which you can then obtain interest.
Yes, it's the principal sum, which is the amount of tax overpaid.
Yes, as I understand it, you're saying the transfer of value in respect of which the claimant suffered a loss is the principal sum.
The transfer value is a principal sum, yes. There's a transfer. Conceptually, it might be thought that it's said there's a transfer of two things. I think that's the way it's put in some cases. Transfer of the money and a transfer of the opportunity to use the money.
Yeah.
Which I've always personally submit is rather artificial construct. But anyway, that's what was said, that there are two things transferred.
Yeah.
But in any event, both of those were reversed when the money was repaid by set-off. It couldn't be either the money wasn't there anymore and the opportunity to use it wasn't there anymore because it had been
Yes, I mean, really, your argument's pretty destructive, I think, of SEMPRA, isn't it? Because or at least of some of the wider things said in SEMPRA.
Yeah.
Yes.
Because you're really saying that the transfer of value is a once and for all event when the tax is mistakenly paid.
yes.
That's your transfer. You're entitled, therefore, to the money back. And there's no separate transfer of value in respect of the time during which the recipient of the money.
Well, even if there is, I think we would accept that you might conceptualise it as that, but in relation to the Category C cases, we would say that whatever that is has been reversed.
Yeah.
When the ACT is set off.
Insofar as during the period prior to set-off, the money has been at the disposal of the recipient, the mere set-off of the principal doesn't restore the money, the benefit of the money which was at the disposal of the recipient, which benefit measured in terms of compound interest. In other words,
that's why there's a claim at that stage to recover it.
well, why can't you, on the question of what a transfer is, I mean, if I lend you my car for a week, I'm lending you, aren't I, the use of the car, the benefit of the use of the car in the week, and I wonder if I give you
it back,
money, aren't I giving you the benefit of the use of the money, and isn't that part of the transfer?
Well, taking that case, if I give you the car back at the end of the week,
Yes, but you don't give the use back.
I'm giving you the use back.
No, you've had the benefit of that.
Yes, and you might be entitled, argue in some circumstances, to claim for that, which has occurred then. But the use, the opportunity to use, doesn't continue after.
No, but it continues, so to speak. The value of the use continues unredeemed and unrequited.
Of the previous use, yes.
Yes, and so why shouldn't you continue to get compound interest on that? I suppose that's different from saying you get compound interest on the actual principle.
Opportunity to use it, yes.
Could you say that the cause of action accrues the minute you pay the money?
Exactly, yeah.
And there isn't a series of continually accruing causes of action.
Yes, that's true.
Yes.
And so you couldn't, as it were, I mean, just say, for example, the day you paid the money was more than 6 years ago, and it was now a time-barred claim.
Yeah.
For the principal, you couldn't have a separate cause of action, I don't think, accruing.
Exactly, my lord, yes.
Yeah.
Yeah.
So if that's the right analysis, it's simply a debt, and interest flows on the debt.
Yes. That's correct.
And the only difference from other debts is the debt founded in
unjust
in
enrichment.
the obligation to the restitution of the obligation arising from unjust enrichment rather than contract.
Yes. And no one would suggest that if there's a contract debt outstanding, that there's a restitutionary claim to recover interest for that. That's a point. Can I deal with then the final point, issue 3, in a few minutes? Can I just first of all clarify? I was slightly surprised when your lordship suggested there was a procedural objection to this.
No, it may be that I'm wrong.
I don't
Well,
think
there is an
there is.
objection on the grounds it wasn't argued below, but you
No.
say it couldn't be.
Well, yes, and it was reserved, I think, as the claimants themselves say. What their objection was that it's not a matter of general public importance, I think.
Yeah,
what they
well, that's
said.
another point they made.
Yeah.
Yeah.
But we would submit that once you've cleared everything else out of the way, it's reasonably easy to determine this point. The example which we gave is at paragraph 172 of our case. This is a simplified example, but it is designed to illustrate the point. And there's no doubt that there are considerable, substantial numbers of situations in which this has arisen. We know that because we've agreed in the Statement of Facts and Issues the difference in the result of this case, of the monetary result, depending on who's right on this issue. So there's no doubt that there were a lot of cases in which Prudential paid lawful ACT. So that's the £100 of ACT on 14th April 1993. The ACT was lawfully charged and paid. And then Prudential later became liable to pay corporation tax for the accounting period. Now, of course,
what was the Court of Appeal held in this?
They haven't held anything on this, my lord, because they said paragraph 124, they recorded at this point they were bound by the previous Court of Appeal. Sorry, did you mean by that
I meant in the FI.
in FII?
Yes.
Well, what they said about it was that because ACT is regarded as a prepayment of corporation tax by the European Court, that means that there must be an action to recover the ACT, which has set off against which purported to set off against the unlawful corporation tax. That was the
even
reasoning.
though it's still available, because there was nothing to set it off against, and you say that this is really, if anything, a damages claim, do you?
Well, we say the only way any claim could be mounted, either in an unjust enrichment or in damages, would be if the claimant were to demonstrate some further loss or enrichment of the revenue, which would occur at some other time.
Yes.
As a result of this.
Yes, because you think that you no longer have the ACT available because you think it was necessary to discharge the unlawful
Yes.
Mainstream tax, and therefore you might have lost the opportunity to use the ACT to set off something else.
Later on in a further accounting period.
So you say that all requires proving.
That would require them to prove that, and our understanding is that there was very little capacity anyway in Prudential, but whatever, the claim that they've brought and succeeded on, it doesn't require any proof of anything like that. It's simply a claim because there was lawful ACT set against unlawful corporation tax, they get it back. That's all
They say really we've lost it, whereas you say all that's happened is that
You haven't used it.
you haven't used it. Maybe someone
Yes.
has a thief has walked off with it for 10 minutes, but you've got it back.
Yes, well, can I deal, there's two possible situations, two possible answers. One is it wasn't actually set off as a matter of law, which we would say is the correct position. It would still be available, and it could be used in the statutory provision, statutory things.
If you realise, once you realise
Yes.
that revenues
Well,
charge was the mainstream tax was unlawful.
Yes, but as I said, there are a lot of accounting periods from 94 open still, so it could still be applied if it did exist. But the other alternative is, they were wrong on that somehow it was in fact used up so that it couldn't be used later. Now, I don't know if that's the case that the claimants are putting forward, but I'm just positing that as the alternative. But even in that case, that wouldn't found a claim for enrichment at this point. Again, it would only found a claim in either enrichment or in damages if they could show that at some later point this resulted in the revenue being enriched or the taxpayer suffering a loss if they're claiming damages. Let's imagine, for instance, that Prudential was never able to use any more ACT than it actually used. So it had no capacity to set ACT against corporation tax thereafter. It would have suffered no loss. There would have been no enrichment of the revenue. The fact that this ACT disappeared, if it did disappear, wouldn't cause any enrichment or any loss at that stage, or indeed thereafter. So they would have to prove that at some point before 1999, when ACT was abolished, that they could have used it, and that would have resulted in a smaller amount of corporation tax being paid in that particular year. But again, that's not the claim that's being brought here. And we say the simple conceptual fact, the fact that the European Court of Justice conceptualises ACT as advance payment of corporation tax doesn't mean that there was an actual payment of anything at the point in which the ACT was set off against corporation tax. All that simply happened was there was an unlawful charge and it wasn't paid. And the reason it wasn't paid doesn't matter. So, my lord, those are our submissions.
Thank you. very much. Mr. Baldry?
Nothing to add.
Thank you. Well, we'll resume at 10:30 tomorrow. Look forward to hearing you, Mr. Aronson.